think you were about to respond to Mr. Steele's assertions about the indictment and YSL being our witness testifying about them being a criminal street gang.
Yes, Your Honor. So first, there was the assertion that Investigator Racy had to be a expert to talk about the fact that his investigation led that YSL is a gang. That he does not need to be an expert. That is what his investigation revealed. Within the indictment, Your Honor, while the specific charge identified the blood gang, when you look at the preamble or the background of this indictment, especially the RICO charge, it talks about YSL and YSL being a blood gang subset. And my next question I was getting ready to pose to him before the objection is, you said subset, tell me what do you mean? So he could have elaborated as to what was contained further in the indictment, which was in the charge it says blood gang. However, he knew and learned from his investigation that YSL was a gang. Why is this important? If you listen to this call, Your Honor, he talks about in the indictment that it said YSL Enterprise. And so at that moment, he asked Amina to put him on the paperwork. So it looks like, well, he tells her, I need you to put me on the paperwork. And then later on, he tells his girlfriend, remember to tell Amina, put me on the paperwork so it doesn't look like street business. And so what I have to get the witness to testify and the jury can believe or not is, well, what did you understand it to be before? And why is that significant that he needed to be placed on paperwork so it can look like it's not street business?
Yeah, I remember us talking about this last week.
And so it puts the call in context, and that's why we went into that line of questioning.
Anything further, Mr. Steele first, and then Mr. Sharp?
Yes.
Because I did cover this last week. We covered this already, so.
Your Honor, I don't understand how Mr. Williams is having a trial that's fair.
I'm sorry.
I don't understand, from my perspective, Mr. Williams is not having a fair trial. I cannot cross-examine Mr. Winfrey. Now, this witness is telling us what he means by having things not look like street items.
Shit,
whatever.
I remember.
Okay.
Okay, so.
I don't understand how any of this is coming in. Amina Diab is not a witness that the state is calling at all. I don't have a burden, you keep telling me, which I know the law, but you keep telling me that, but it feels like I have a burden because I have to clean all this mess up. And the
if you choose to do so, sir. And that's your characterization of it. So
the indictment, quote unquote, redacted, is a farce. This thing has, I don't know if you looked at your copy, there's blanks here that identify Jeffrey Williams. I mean, you'd have to be a deceased person not to realize that the indictment is charging Jeffrey Williams in it. And the state just goes on like, this is no big deal. You know, I have a big deal. This entire case should have witnesses who are competent to be cross-examined, and they don't. I, again, object. This gentleman is testifying. He has no basis in saying what Jimmy Winfrey meant or didn't mean. The recording, because of your ruling, speaks for itself. He shouldn't be able to interpret it, just like I can't interpret it. And it was never even done. What the jurors won't know is that Amina Diab didn't give any paperwork at all. Yeah, in fact, what they don't know is that Jeffrey Williams, because the state won't probably play it, a recording with Jeffrey Williams where this detective asked Jeffrey Williams, does Jimmy Winfrey work for you as your road manager? And Mr. Williams laughs and said, are you ridiculous? I have real legitimate people. So all of this is the state of Georgia getting out a theory that is not based in fact and that should not come into this courtroom. This entire, since the state has been allowed to say, does this help the investigation? This case has gone south. Maybe it was south already, but it has gone so south, I can't do anything. Those are all my objections. I'm moving for a mistrial. I have no idea why this gentleman got to say Amina Diab works on the legitimate side of the business. We're presumed innocent. He has no right to say that. And then this indictment is all hearsay under the Brown case, State versus Brown, which the Honorable Court agreed with, yet the state's using the indictment as a weapon. They're saying it says it in the indictment. Mr. Winfrey pled Alford. He's not testifying. You let it in as a statement against his penal interest. Well, that's only against him. He's not on trial. It can't be a co-conspirator statement because it is a statement that does not further any supposed conspiracy because it spills the beans. So for all of those reasons, I mean, we could just use one, but for all of those reasons, I named 3, 4, 5, or 6, I'm respectfully asking the court to strike all of his testimony that goes into anything anyone else said and the investigation, and let's wipe this slate clean, and please, I just want to go forward and have people to cross-examine.
This is the second time you've made the same argument, sir. I understand it, and it's your right to do so. All right. Unless you have anything else, Mr. Shart?
Your Honor, of course, I agree with what Mr. Steele just said about Jimmy Winfrey's plea being coming in as evidence against the rest of us when he is not taking the stand. But I'm going to go one further than Mr. Steele because in their line of questioning, they are asking about the indictment that Jimmy Winfrey pled to. And the jurors are following what they're talking about. They're asking about the indictment, their indictment, the plea. And then they say, and what gang was involved? And then the investigator's going to say YSL when we can all look at this indictment, which shouldn't be coming in evidence in my estimation. But if we're going to let it in over our objection, at least let's be honest about what it says. It doesn't say YSL. He pled to the count.
The preamble say YSL?
He pled to...
Does the preamble say YSL?
Preamble?
Does the preamble... Answer my question, please.
Sure, the preamble does, but
okay,
not the
all right.
count.
So you
Not
have to
the
read...
counts that he
Okay,
pled to.
you have to read the preamble in conjunction with the
Your Honor, he pled
with the
to
counts.
specific
It's just
counts.
like it's similarly situated to the preamble that you have in this indictment.
But he pled to specific counts, Your Honor.
Okay, but that
The
doesn't mean
preamble-
that the factual predicate of the preamble doesn't apply, right?
Well, I suggest that...
Does it apply or not?
I disagree with you completely.
Does it apply or not?
No, it doesn't.
Okay,
It
all right.
does not. He pled
Okay.
to specific counts.
Okay.
And the state really missed an opportunity because they should have made this indictment 3 times as long, and they could put the whole story, the whole narrative in this document that we are not defending ourselves against, and we cannot cross-examine, and they could have put it even more in front of the jury. This is the way we're going to do it.
Okay, all right. Your second argument as to this as well. Okay, anything else, Ms. Hilton?
Your Honor, I think the state has said it. Given the jail call that we just listened to, Mr. Winfrey himself referenced the indictment and referenced him reading of it. And so all of my questions followed through based upon that jail call. Given that this was an open pending investigation at the time that this jail call was made, this is relevant area of what was relevant to Agent Racy at the time where he heard this jail call, which is there was an indictment, it was open, and now in the midst of his investigation, Mr. Winfrey is asking to be put on the paperwork. We can infer it's the legitimate side of the business. Now, if Mr. Steele wants to argue that Ms. Diop was not a part of the legitimate business, they've been arguing throughout this entire trial that YSL is a music label. So that would be the legitimate side of the business. If their argument is no longer that doesn't exist, then we can move on. But for the purpose of this call references him trying to get put on paperwork so it doesn't look like street business. Paperwork, legitimate, street business, not legitimate. And so we are trying, this became relevant to him, Your Honor. And given all the reasons that we have stated before, this wasn't spilling the beans. This was him trying to cover the conspiracy, which was him shooting at the bus involving Mr. Dwayne Carter. So for all the reasons stated, Your Honor,
right.
We would exit. You said overrule the objection.
I'm going to overrule the objection, Mr. Steele. I will give you a continuing objection. I'm going to note that you've moved for mistrial once again. I'll also note that you have asked the court for a mistrial again before the positing of the next question. So with that,
I'm joining the oath for mistrial. And also, I'm asking you, in granting that continuing objection, are you granting it to all of us?
Yeah, the Harvey rule applies unless otherwise stated. So it would apply for all of you. The motion for mistrial as well as the continuing objection.
I'll ask for a motion to sever parties then.
Okay, I'm going to deny that motion at this point in time, sir.
105 instruction.
And I will deny that as well at this time. Okay.
Yes, sir.
If I can address the court briefly. I filed a supplement to the Mr. Kendrick's motion for a mistrial this morning. I just want to make sure the court's aware of it.
I am aware of it. I have not yet had a chance to look at it, but that's, got it.
Thank you, Your Honor. Mostly I want to make sure I bring it to the court's attention because again, and I've followed the request of the court to not argue what's already in the papers, but I just want to make sure that the court understands that based on this additional information that we learned about the July 7th meeting, that my client has been consistently denied his right to a fair tribunal. It's been a due process violation. I, like Mr. Shart, am extremely upset having read that transcript. Myself and my fellow outside agitators over here, I assume that they are upset as well. And
I don't think, honestly, I don't think that that reference was to anybody who is a member of the bar. I think that there have been times in this case where members of the public are in the courtroom, which they are, of course, entitled to be, but communicating in ways that are not appropriate.
well, you know, the problem, Your Honor, is that since this was an ex parte meeting that should probably have never taken place, you were not there, I was not there, my fellow outside agitators weren't there, we don't have a video of it, so I have no idea specifically if that was not referred to us. We don't know, do we? We don't know. And what I do know is that I have been arguing with people for 18 months that Chief Judge Glanville was doing his best, that he was trying to rule to the best of his ability based on the evidence and the law before him, and now I have been made to look like an idiot. So
well,
I do not believe that this trial should continue, Your Honor.
I understand. Thank you. I'll take your supplement under consideration. Like I say, I haven't, obviously you just filed it and I haven't had a chance to look at it yet, but I will consider that in the overall context of the motion I was already considering. And, you know, I don't know that everybody's not going to want to come up here and do their 5 minutes of how outraged they are. If y'all feel like you need to get it off your chest, come on. Now's the time.
Okay, I got one more thing to say there. And then I'll sit down.
Okay.
And I don't believe that this is performative outrage, Your Honor.
I mean, I don't either.
Okay.
I don't either. I already said I understand.
In July of 2023, after months of me complaining about late discovery from the state, which should have been produced in December of 2022, when another terabyte or so tranche of discovery was produced to us, I begged Chief Judge Glanville to put a hard deadline on the discovery being produced from the state. He refused to do so. And you know what Judge Glanville's response to me was when I will tell you. I will tell you what his response was. If this was a civil trial, I would keep this out. But since this is a criminal trial, it's coming in. If this was a civil trial, if it was about money, I would keep it out. But since it's only about Mr. Kendrick's life, that last part obviously wasn't in there. But if this is a civil trial, I would keep it out. I've been a civil litigator for 25 years. I agree that if it was a civil trial, it would be kept out. What I'm shocked by, and I'm new to criminal, what I'm shocked by is that the standard would not be higher in a criminal trial. But what did I say to people? Chief Judge Glanville is doing his best. He is doing his best. And now, again, I don't even know what to say to my client, Your Honor.
All right. Well, you know, I don't know. Obviously, I don't know what to say right now either. But I think that, while again, I understand frustration, let's be careful about disparaging a respected judge. I do think that he has, and I haven't looked at every transcript yet because they haven't all been produced yet, but I don't think you're wrong that he has been trying his best and doing his best. And, we all as lawyers know that everybody talks about lawyers trying to herd cats, and that's not inaccurate. This is a big case. There are a lot of good litigators on this case, but with a lot of good litigators probably comes a lot of egos as well. And I think sometimes it is possible to sort of get so enamored of your position and of winning a point that you are focused more on that than on backing down and taking a breath and being amenable to hear what the other side is saying. And hell, that's true in our whole society right now. Should have said hell, but y'all, I mean,
You're
all right.
Those were not my words. Those were Chief Judge Glanville's words. If this was a civil trial.
Well, I don't know why it was. I don't know what evidence you were talking about. I'm sure there have been evidentiary rulings that have been frustrating to both sides. I will look at the two transcripts and I will make a ruling. And again, I don't think that the characterizations are exactly accurate, but I'll consider it all in context and I'll make a ruling.
Thank you.
All right. Anybody else, or can we move on to evidence? Mr. Steele.
So there are 16, and good morning again.
Good morning.
Good morning, Madam Court Reporter. Ms. Winfrey, there are 16 hours approximately of the video audio you're talking about.
Okay.
And yes, we were going through to dissect objections, but I, and among others, really had an overall objection because the witness testimony, which is before the afternoon of June 12th of 2024, he agreed that he said these prior statements. So over objection, and the way I understand the law, the state shouldn't have been able to put in at all. So I understand what you're doing.
Okay.
We're going with you, but I just want you to know that we're not conceding that the way it came out, and obviously it's going to be redone after, I believe, I heard what you said. Yes, I agree, but that's the law. I don't believe that it should come in at all. So before you tell us later, why'd you make me do that?
No, I understand. And I think that Mr. Shard had actually put that particular objection in writing in one of your filings anyway, essentially that to the extent that Mr. Copeland said, yes, I said every one of those things to police officers, but every one of them was a lie. That is an admission that he made the statements. And the defense position, as I understand it, is as long as he acknowledges the statement, then nothing else is a prior inconsistent statement. And I'll hear from the state with regard to that, but...
Can I add one thing? Just another layer of that. Oh, I'm sorry.
Go ahead.
Just another layer of that is that the issue, the subject matter of these statements is largely the alleged co-conspirator statements, that our stance is that those were not in furtherance of conspiracy either. So there's like two layers of analysis.
Okay, thank you.
I'm sorry for interrupting.
You asked, I let you. But anyway, with regard to, does that make something said that is inconsistent in a prior inconsistent statement? And the state can provide me the law on that. But I think there are times when either an I don't remember or an I don't know or a, well, that was a lie, can still form the basis of making something a prior inconsistent statement. So, but
And Your Honor, I'm going to let Ms. Hilton speak specifically as to the law on factually what Mr. Copeland did say. What he said was, I don't remember anything that I told the police. I keep telling you, I don't remember anything. But if they say I said it, then I said it.
yeah, I think what they're talking about is he also at certain points said, yeah, I absolutely said that, and it was a flat out lie, and I'm paraphrasing, but
Okay.
that is what they're talking about, correct?
If that's what they're talking about.
Is that what y'all are talking about, Mr. Sharp, Mr. Steele? Yeah, so that's what I would like for y'all to address.
Your Honor, we believe based on two positions, OCGA 24-6-621, which be impeachment by contradiction, as well as a prior inconsistent statement, both that statement, I said all that I said, but it was a lie, or I was trying to finesse my way out of being locked up, would lay the grounds of still allowing the prior inconsistent statement to come in.
Okay, and 24-6-621 is the
Impeachment
by contradiction, and 24-6-613 is essentially prior statements, right?
Yes, Your Honor.
So what I'd like is some case law that represents the proposition that you are asserting, okay?
Yes, Your Honor.
All right. And I don't want it just simply quoted out of a horn book. I would like the actual case law.
Your Honor, if you can give us a moment, just because
Okay.
we need to.
I mean, y'all, when I told you a week and a half ago that I wanted to be going through Mr. Copeland's evidence, y'all had 10 days or more to get ready for this. So I don't know what y'all thought we were going to be doing, but yes, I'd like to hear it. So if you need a minute to get me the law, go ahead. We can also do this portion after lunch and do something else right now, because I don't know that we all need to sit in court and do our research. We have to decide how we're going to instruct the jury about what to consider and what not to consider as to Mr. Copeland's testimony. Now, this assumes, this assumes that Mr. Copeland decides to testify. Obviously, if he decides at this point, on Monday not to take the stand at all, then it's a pretty easy instruction because it's disregard everything you heard from this witness. But if that's not the case, then does anybody have a proposal for how we are going to, and I think that's what the state had sent something on. And has the defense had a chance to look, and is there, I think Mr. Williams maybe has just sent over his proposed instruction, which hopefully everybody has gotten. All right. All right. So Mr. Williams' motion, his language, that looks pretty good to me. Obviously, we don't need to include the case law sites, but I mean, that looks like a good thing to sort of work from. Now, one thing I guess I was asking, but not very clearly yesterday, was it seemed like there was kind of a fairly clean break between the topics that were covered before the recusal motion and the topic that was covered after the recusal motion. And that being, I think like on the one day, the question opened with, all right, now let's turn to the murder of Nutt or the murder of Donovan Thomas or whatever. And that was after the recusal motion had been filed. So Was there any discussion of the murder of Donovan Thomas with Mr. Copeland prior to the recusal motion? Because it would be pretty easy to also say, not just with regard to dates and times, but anything about the Thomas murder disregard, if that only came up after the recusal motion was filed.
Your Honor, with respect to any reference, I haven't had a chance to listen to all of it and read all of the testimony that and all of the questions that Ms. Hilton asked of Mr. Copeland. But I can say that so I at this time I would ask that the court not instruct the jury as to disregard any specific subject, because.
Well, I'm wondering, so I mean, y'all have had the point of getting y'all all the testimony was, well, one of the points was so that you could look at it.
Yeah, I mean, I'm not saying I haven't looked at it. I'm looking for and reading it.
Yeah, so I mean, if there is kind of a break in terms of subject matter as well, that'd be an easy thing to instruct on. But does anybody know the answer to that?
So the
You do? Okay. What's the answer?
I misspoke yesterday, but there were video portions of Mr. Copeland's statements on early morning hours of January 11th, 2015, as well as January, I think it's 21, 2015, played for the jurors.
Uh-huh.
They were small. They were like, quote unquote, real impeachment.
Right.
After that, though, after the motion to recuse was filed, is the wholesale playing of various recordings. So I don't think that it would be appropriate to say disregard everything. I have all my notes.
Okay.
And I have the transcript.
Okay.
But he did discuss things that you're talking about. He did discuss his relationship with Mr. Williams, his relationship with Donovan Thomas, with Mr. Kelvin Watts.
Right.
So
Yeah.
he was getting there.
Okay, but if it's all that sort of background relationship stuff, that's not the murder of Donovan Thomas. That's all the background. So what I'm trying to sort out is, had there been any testimony about the actual, here's the night of the murder stuff before the recusal motion?
So, Judge, it's when you say about it, in as much as it's relevant to the issue of the murder itself, that's the reason why I was asking the relationship between parties and all of those kind of issues.
That's not what I mean, and we can be clear about that. I mean, the night of the murder, the what happened, how the murder went down.
I think it's safe to say that as far as Mr. Copeland is concerned, the specifics of the night of the murder information or evidence was given post-recusal motion.
All right. Is there anybody that disagrees with that? All right. Thank you.
Would the court consider the state's position that in characterizing any evidence in any way, it could imply to the jury that certain other evidence does not fall into that category? So in other words, any evidence of the night of the murder, I'm not certain how the court will be instructed.
I'm not either. That's what we're supposed to be tailoring today. That's what I wanted y'all to be giving lots of thought to. But yeah, no, I want to tailor it in such a way that I don't mislead the jury about anything. But y'all all agree that we have to tell them to disregard some of it. And I mean, yeah, maybe the cleanest thing to do is, XYZ date, but people don't normally think about their lives in, June 3rd. Okay. I know exactly what June 3rd had to do with, unless it happens to be their birthday or something like that. But so, yeah, I mean, I'll consider all of what you want to offer me, but okay.
I personally, I'm not speaking for, I went by my notes as well as a transcript, but my notes have more things, I guess, I don't, they were my notes, but I don't have anything specifically talking about the Donovan Thomas murder before Mr. Weinstein filed the motion to recuse. I do have like a January 11, 2015 interview by Detective Thorpe of Mr. Copeland.
Yeah.
It is admitted over objection, and it was played from 3:29:46 to 3:30:13. And I have to go back and remember what that was about, but I have little things like that, but I don't have any specific.
That's very helpful. And I knew there were a couple of small snippets of videos played. So if you've actually got the timestamp as to what parts were played, then it's easy enough to have somebody look at those snippets and see what it covered.
Can I announce now, or?
Yeah.
So everyone can check. I have States Exhibit 378Y, as in Yankee, B as in Barry, 6, and these are the time slots, 6:46:34 to 6:46:44, and that's a January 28th, 2015 interview.
Okay.
And then I have, the January 11, 2015 interview marked at States Exhibit 358A as in Elisa, and it's at the time I just said, which is 3:29:46 to 3:30:13. That's what I have. And then I have nothing else about specifically his interviews after the killing.
Okay, 3:29:46 to
3:30:13.
Okay, thank you.
And that's at 358A as in Elisa.
All right, and I think that's our review had only revealed those two, anything from those two videos also. All right, anybody else have a different recollection about either more videos or the specific topic of the night of the murder having come up prior to the recusal motion? If so, please let me know.
Previously, the predecessor court came to the court's attention that there was a release of what I'll call discovery, but it's October 27, 2021. And it's a recording of an interrogation of Mr. Copeland, and it was very harmful to Mr. Williams. The part that was released that I'm aware of, and I believe Mr. Adams, unless he corrects me, just has lies, what I can say lies, about Mr. Williams ordering people to die. It was very harmful. I asked Judge Glanville, predecessor judge, for relief and a bond because it denied Mr. Williams' right to a fair trial. The predecessor judge said there's going to be an independent investigation of who released that, and that he would get to the bottom of it. I never heard back from that. A jail call, I listened to all these jail calls. We had others listen to all these jail calls. On a jail call, I didn't
I didn't say anything last week. I played a jail call where Mr. Copeland said that immediately after telling the authorities in December and February, December 22, December 23, that he had lied and that everything he said was a lie about Mr. Williams, and he's telling this to his friend and his sister. He said all of a sudden, this jail call, this interrogation was released. So he believed it was the prosecution team releasing it. That's how it all came up. For a prosecutor who's an advocate to then vouch for and put her own credibility in issue, that's what I've been objecting to. And to say, we gave it to the defense, and I'm raising my voice because I don't have a amplifier and microphone. So I'm not trying to yell. Court is shaking the head with a smile. My point is, sorry, Your Honor, is that it sounds like I did something wrong. I didn't release anything. I didn't do anything wrong. I was the one objecting to the release of this information. And it was given out, and I'm not very technical, so it was given out on Dropbox, and I was told that's a bad way to do it. And Judge Glanville, then predecessor judge, said, don't do it that way anymore. Yet the Dropbox was never taken down. It was all a mess. And the predecessor judge, and I'm not casting aspersions, they may have been a great investigation. I just never heard anything. And now we're here on Tuesday, the 3rd day of September, and the prosecution is asking questions which clearly target that did you know that within X amount of time that the defense got this discovery, which the previous answer was no. I don't know when the defense got the discovery. There's no foundation. That doesn't stop the district attorney of saying then it was released. Clearly, it's the same pattern that they've been given about all these witnesses. Mr. Trotavia Stevens, Mr. Bean, B-E-A-N, Mr. Murphy, this witness. Have you ever had to testify in front of Jeffrey Williams or these other people? Now all of a sudden, your testimony is different. And I've been objecting every time because there's no evidence of intimidation. And what happened, which you may not know, and this is based on information belief, I never spoke with Mr. Copeland about this, so maybe it's not true. I believe he got beaten in the jail after that was released. I believe, I could be wrong. But assuming that's all true, for the prosecutor to now say that their hands are clean, and I can't ask the question. Judge Glanville denied my request to call the prosecutors and their agents to assert under oath, under questioning, who released this. Because it certainly wasn't in Mr. Williams' best interest. So anybody on Mr. Williams' behalf would be would do a disservice to release that Mr. Williams is having people killed when we're in the middle of jury selection. So anyway, my bottom line is this entire, Ms. Hilton has taken, and I have all the cases we argued before, but has taken herself, and she has moved from the position of asking questions and an advocate to testifying as a witness. You told me, I was there. Detective Long's out of the car. You told me. You only told me this. Did you know that the prosecution served this? Were you aware that the defense had this? All of this needs to be questioned to Prosecutor Hill. So I asked the court, I know I've been repeatedly asking that, and I know that I have a continuing objection, but this is not how we try cases in the state of Georgia. All of these cases require Ms. Hilton to take the witness stand. And if she does, I have no objection because I'm not a witness. But it's been denied. That's my objection. I'd like her to be removed from the case. I'm not trying to stymie the prosecution. They have other witnesses. They at counsel table, 3 other lawyers. I mean, this is not new. So I ask for the prosecution that specifically Ms. Hilton and Ms. Love to be removed from the case. I have questions for both of them. I also like to renew my motion I could call predecessor judge. That's my entire objection. The mistrial motion, I don't want a mistrial. I'm telling you what I don't want it. Because this has to stop. And now those last questions had to be with the intent of casting aspersions on not only Mr. Williams, but I presume everybody else here by saying that we're releasing information, which I assume maybe it's not true. So I don't want to go too far. But the next question will be, and you got beaten
me my next question because I didn't know he got beat up in the jail. Your Honor, last week when Mr. Shard, I believe, asked.
Let me interrupt you a second. He may not have. I just want to make clear that may not be accurate. I don't have any personal knowledge, or I was not told that.
Last week when Mr. Shard asked he went down a line of questioning about this call being released. And Mr. Shard asked Mr. Copeland who was his belief, what was his belief of who released this recording? And the state objected, saying that it wasn't relevant who he believed released this video. The court overruled the state's objection. He was able to answer that question, which was he believed it was the state. And at this point, we believe that it is proper for the same reason that he was able to disparage that the state will release such a video.
Okay, you need to be careful about what you're saying, because there are questions from the attorneys and then there are answers from the witness stand, and that's what the evidence is. And I do not believe that anybody on the defense side made the suggestion that the state had released it. I mean, the transcript will reflect what was asked and what was answered, but
and maybe not disparage is the right word, but the question was asked, who do you believe released the video? And he says, I believe it was the state of Georgia. I believe that an appropriate line of questioning, Your Honor, is would he feel differently if he thought that the defense leaked it? And to give questioning about what his understanding of, what Mr. Copeland's understanding is of what happened and what transpired when this video was released.
well, we already know what Mr. Copeland's belief and understanding is.
But would it change if
That's not what you asked, though.
But I had to give some foundational questions in order to ask that question, in order to answer what my next question is. Because another question I'm going to ask him, and it's something he alluded to earlier, was that after this video was released, Miss Love, Investigator Long, Miss Rolak all visited with him after this video was released to check on him, to make sure that he was okay. And he alluded to that earlier when he thought I was present at the meeting. And all of this happened around the time that the video was leaked. And so I was asking some foundational questions to Mr. Copeland to see if his position would be different if he thought that someone else leaked it and not the state of Georgia.
Then you should have asked that question.
And I can get to that series of questions, Your Honor, but
I mean, you are coming very, very close to the line with this line of questioning. I mean, you're basically, the defense is not far off. Let's just put it that way.
So I mean, I can move to my last two questions regarding this, which is who came to visit him after the video was released, and would he feel differently if he believed that the defense leaked the video?
No, I'm not going to let you ask that last question at this point. I mean, that's a total hypothetical question. That is an assumes facts, not an evidence question. Not the objection you keep making.
Your Honor, I feel compelled to just make a brief record. First of all, any insinuation that I asked a question about the release is way off. That topic never even came up during my cross.
You know what, and I know you're not finished, but let me just say that I believe that this jury is paying attention and that they have enough wherewithal to remember what actually happened, and for questions that are potentially misleading, I'm not sure why they're being asked, but I think the jury's gonna take note of what got said. And I understand, but you know, I think the jury is doing what they have been told to do, which is to pay attention to the evidence, not the questions.
And second, Your Honor, I just want Your Honor to understand kind of the backdrop here. I guess there was a release. I don't even remember the time that it was released, but apparently it was on social media. When that came to the attention of the court, to my recollection, from my vantage point, yelled at the defense, and this was prior judge, and essentially blamed us. And all of us were saying, well, we didn't do anything. I personally don't even know how to release a video to the press or the internet anyways. But, you know, I just went along with it. Okay, there's going to be an investigation. We're being told we're under investigation. And then all of a sudden, no one mentions the investigation anymore. And it's kind of like, well, if you're accused of something, you would like to know the progress of said investigation.
I'm certainly happy to ask the predecessor court's chambers what's going on with it, if anything, but that's not really relevant to what's before this jury.
Well, it's not until the state, knowing that there was an investigation, knowing that they haven't heard of any findings, then lights this thing on fire again and starts suggesting that we did something wrong. And, you know, I can only speak for myself. I don't believe anyone did anything wrong on this side. I know I didn't. And then somehow those insinuations are coming out in front of the jury with absolutely no basis. And I'm going to join my my friend Mr. Steele, and I'm going to state in my place that I believe the state at this point is goading a mistrial and goading us to move for a mistrial. So I just think that was very inappropriate, and it suggested things that there is just no basis. And in fact, there's apparently been an investigation, and it's been settled as far as I know.
Well, I don't know what has happened, if anything, with that. But would y'all like to address the assertion that you are goading the defense into a mistrial?
Yes, Your Honor. Number one.
Right, into a motion for mistrial.
Yes, Judge, thank you. Number one, we don't want a mistrial. We vehemently object to a mistrial, and we do believe that the line of questioning, whether it was posed by Mr. Shart or Mr. Steele regarding Mr. Copeland's belief about who leaked that video, was, one, not relevant, but understanding that the court ruled as it did, we believe that an inquiry whether his belief that the state leaked the video had some impact on how he decided to testify would be a valid question.
Okay,
since
that's, again,
asked.
not what y'all asked.
Understood, Judge, understood. But I vehemently object to a mistrial. I do not believe that anyone here at this table has done anything, anyone at this table or on the state's behalf has done anything to in any way merit, warrant, call for, justify a mistrial. So we definitely object to a mistrial. And Your Honor, as it relates to the assertion that counsel for the state have somehow made themselves a witness, repeatedly the witness has affirmed that there were people in the room whom either counsel for the defense could call without having to disqualify either prosecutor in this case. So that being obvious, we definitely object to a mistrial, and additionally, we object to the speaking objections that are being made while the jury is in the box.
All right, well, I'm going to overrule that objection. I don't think that that is going on. Sometimes it's just not particularly clear what the objection is, and if I need further elucidation, then I have permitted that. But I'm going to overrule the motion for mistrial and or deny the motion for mistrial and deny the motion to remove either Ms. Hilton or Ms. Love from the case. I do think that it appears from the questions that there was somebody else present at every meeting. But, you know, Ms. Hilton, that's another option as well.
Did you, before you talked to Mr. Zachary, did you in any way alert Mr. Zachary by any member of his family or any other way to the approximate number of vehicles that you saw in that video?
No.
Outside of the investigation that was conducted by Detective Dennis in that Little Wayne bus shooting, did you have independent information that about the details Mr. Zachary gave you during that August 5th interview around the Little Wayne bus shooting?
No.
Do you know whether Detective Dennis had information during his investigation that could corroborate or disprove parts of what was being said?
I'm not sure.
Have you ever had interviews where you're sort of forced to decide or determine whether somebody is trying to put blame here to get blame from somewhere else during your time as an investigator with the gang unit?
Sustained.
Okay. During your interview with Quindarius Zachary, did he give you any indication that his reason for talking to you was to get Shannon in trouble and get Demikian or Woody or Muntu out of trouble?
Objection, Your Honor, bolstering
Speculation.
and speculation. Thank you.
Yeah.
Overruled as to speculation. Overruled as to bolstered.
You may answer that question. Do I need to ask it again?
No, I think I understand it. No, it didn't appear that he just wanted to get them in trouble. I took it as he wanted to try to help himself as much as he can by providing truthful information.
Speculation.
Overruled. Well, sustained as to speculation.
Okay.
I also have a motion, Your Honor.
You have a
Motion.
all right. Time for our morning break anyway.
Your Honor, at this time, I'm going to move for a mistrial on behalf of Mr. Stillwell. We have, first of all, I'll point out that we've been referring to Ms. Gaither as, I believe, Sergeant, and I say that to say that she is not someone that just came off the street to testify with no understanding of how the process works. She's experienced. She's, I'm sure, testified many times before. She just informed the jurors that her belief is that Mr. Zachary did not want to harm Mr. Stillwell specifically, but that's not my objection. My objection is she testified his intent was to come in and give truthful, to get himself out of trouble by giving truthful information. That was absolutely improper. That was vouching for a witness. That was bolstering. And that is the basis for a mistrial. From an expert, I'll point out as well.
Your Honor, my response is that the court very well could and should instruct the jury that as to the witness's opinion about a interviewee's, well, first my response is we vehemently object to a mistrial. Secondly, the court could and should instruct the jury that a witness's opinion about another witness's statements or, testimony or anything that they said is not to be considered by the jury. The jury is the person that determines the credibility of the witnesses. And I can make certain that Sergeant Gaither knows when I'm asking regarding any indication that to not talk about truthfulness, but just to give objectively what indication or whether she considered that there was an indication. Secondly, a mistrial is in no way warranted in this case. When Sergeant Gaither did not say Quindary Zachary was being truthful, she said, I perceived. She said, I perceived. And that is why an instruction would be warranted, that her opinion about his truthfulness is not to be considered by the jury. They make the determination about credibility. There is nothing about any of the exchange that just occurred that warrants or in any way justifies a mistrial. At best, an instruction is called for.
That I initially objected to the question to begin with, and I saw the danger, and the state insisted on asking that question that prompted this response. That was completely inappropriate.
All right, thank you. I'm going to instruct the witness as well. So we'll go ahead and take a break. And when we get back, I'm going to have the witness in and instruct her and then give an instruction to the jury. Going to deny the motion for mistrial.
Your Honor, I'd like to renew my motion for the next question.
All right, thank you. All right, we're on recess.
Assume we're all joined in that.
Yes.
Okay, thank you.
I mean, yeah, 10 minutes. And by the way, that witness, Bernie, if he's not here already, he's on his way, the one who needed to testify in Cobb. So just in terms of scheduling, if y'all want to take him next, he's available. And I knew that we wouldn't be done with this Gaither anywhere near 10 a.m.
I won't feel offended.
Yes. I'm just trying to draft this. Okay.